The federal Liberals are taking aim at hate crimes by introducing a new bill that creates 4 new hate-related criminal offenses. And as CTV's Martin McMahon reports, while some are welcoming it, others feel it goes too far.
Sadly, there is no community that is immune from hate in this country. There are violent attacks against Black Canadians, rising anti-Asian hate. We see Gurdwaras and Mandirs vandalized, and the LGBTQ2+ community threatened with and suffering violence all too often.
Imagine a hockey game where the referee doesn't just call out penalties based on what the players do, but on what he believes they were thinking when they did it. Now, this is akin to a player delivering a legal check in a hockey game, but the referee awards a penalty anyways because he believes the player meant to injure the opponent. Now, you think that's a bizarre, but I want you to apply that to speech and think about it for a moment, because this isn't a story about good versus evil or left versus right. This is a story about what happens when words become weapons for the state and why the consequences could affect everyone. Let me be clear about this from the start. This is not a video about banned words. It's not about accidentally saying the wrong phrase and suddenly you're thrown in jail for it. It's about something more subtle, something more powerful. Because Canada is passing a law that changes who gets to decide what you meant. Not just what you did, not just what you said, but what authorities believe was in your mind when you said it. Now, most people will notice this shift until they're misunderstood or taken out of context or caught in a moment of anger, sarcasm, or in protest. So today I want to walk through Bill C-9 as calmly and carefully as possible and ask a simple question. When the state defines hate, who actually bears the risk? I encourage you to wait until the very end of this conversation, not because I want you to agree with me, but because this is one of those changes that only becomes obvious after it's already in place. And if you get any value from this video, I want you to click on the subscribe button and let's get into it. To understand what's happening, we need to take a look at this piece of legislation called C-9, officially the Combat and Hate Act, printed right here before me. It was introduced in the fall of 2025, just a few weeks ago, to give law enforcement new tools to respond to rising hate-motivated incidents, particularly anti-Semitism and other targeted harassment in Canada. Now, you might remember another more ambitious bill called the Online Harms Act, or Bill C-63, just a few months back under the Trudeau administration. That one was ultimately defeated, but the government's ambition clearly wasn't defeated, at least not yet. While C-9 isn't a direct copy and paste, it doesn't have the pre-crime provisions that caused the problems with C-63, for instance, but it does share the same goal of tackling hate. The government says it wants our laws to be more consistent, more transparent, and effective at protecting people, especially the young. In a climate of rising social tensions and debated speech, you would think, who wouldn't agree with that, right? But the problem isn't the goal. The problem is always in the mechanism used. Bill C-9 proposes 3 fundamental changes to Canadian law, and that we need to take a look at very, very closely. The first is it writes a definition of hatred into the criminal code for the very first time. And second, it creates a new standalone hate crime offense you can add on top of almost any other crime. And third, it removes the key procedural safeguards that were designed to prevent these powerful laws from being misused in the past. Now, this might sound to you like some technical legal jargons or some edits to what was existing before, but each one of these represents a transfer of power away from judges in high-level oversight and towards downstream frontline police and prosecutors. Now, you may ask yourself, so what does this actually mean for you? Let's start with the definition here, because for decades, the legal meaning of hatred in Canada wasn't written into any law book. To the best of my understanding, it was defined by the Supreme Court in landmark cases. For instance, in the R.V. Keegstra case, the court described hatred not as mere dislike or offense, but as the most extreme emotions of detestation and vilification. It was a deliberately high bar meant to capture only the most severe forms of expression that effectively demonizes a group of people or a person. Now, Bill C-9 proposes to take that judicial concept and lock it into the criminal code permanently. The bill defines hatred as the emotion that involves detestation or vilification and that is stronger than disdain or dislike. On the surface, you would think this seems reasonable. It's just like writing what the court already said in the past, right? But there's a huge difference between a standard developed by judges, case by case, painstakingly, and a static definition passed by politicians. I'll explain that here. A judge applies that standard with immense context, looking at the specific words, the speaker, the context, the audience, and the impact it has. On the other hand, a statute is a blunter instrument because once hatred is defined in the code, that definition can cascade into police training manuals, into charging guidelines. It can lose all of the nuance along the way in the downstream. It creates a brittle new weapon that turns a standard that was supposed to be flexible and context dependent into a fixed rule. The goal might be clarity, but the result could easily become rigidity, creating a legal tripwire where a safety net used to be applied. Now, the question isn't whether this definition is perfect or not. It's actually what happens when we empower the state to be the final arbiter of truth and of emotion. This new definition of hate gets supercharged actually when you connect it to the second major change in the Bill C-9, the creation of a brand new standalone hate crime offense. Look at it like this. Previously, if you committed a crime like an assault and it was motivated by hate, that motivation was an aggravating factor at sentencing. The hate made the punishment for the assault more severe in the past. But Bill C-9 changes the game entirely. It now creates a new separate crime called a hate-motivated offense. What does this mean? It means if you commit any crime under any act of parliament, from assault to mischief, and a prosecutor actually believes it was motivated by that new definition of hatred, you can now be charged with two separate crimes instead of one: the original offense and the hate offense. The maximum penalty for this new hate crime would mirror the maximum penalty for the underlying offense. But the real danger actually is more subtle and even more realistic to frankly think about it, because this will create enormous leverage for prosecutors. Now imagine you're charged with a minor offense during a heated protest, for instance. The line between your passionate, angry speech and detestation or vilification can become blurry. A prosecutor could now add a hate crime charge, not because they expect a maximum sentencing, but because it dramatically raises the stakes in that case. It pressures you to plead guilty. It attaches a permanent stigma, and it's all based on the interpretation of your internal motivation, not what you did. This isn't like giving a referee a new rule, as it were. It's like giving the referee the power to call out a foul based on what they believe the player was thinking, not what the player did. It expands what is punishable from your actions to your presumed intent as judged by the state. Now, if you think this all sounds like an overreaction and an alarmist here, you need to understand that this isn't happening in a vacuum. We already had a preview of government's thinking. The now defeated C-63 had an even more radical proposal of a pre-crime peace bond, if I remember very well. It would have allowed a judge to put someone under a house arrest and force them to wear an electronic monitoring bracelet if someone merely feared they might commit a hate crime in the future. I know that proposal is gone in the C-63, at least for now, hopefully, but it shows the trajectory of this thinking pattern from punishing hateful acts to punishing hateful speech to trying to prevent hateful thoughts before they can even get expressed. We don't have to guess what this world will look like. We can look at other places like in the United Kingdom where similar laws have been in place for many years now. The UK has actually become the poster child for a ban on free speech in recent times in modern civilization and even in Western countries. In the UK, UK, police have invested huge resources investigating memes, jokes, and tweets, and people have faced police investigations and had non-crime hate incidents recorded against their names for telling clumsy jokes online or expressing controversial opinions, even on Twitter. The chilling effect is no longer a theory. It's actually a documented reality. There is a UK union that actually documents all of these cases, and it will shock you that about 30 of them are recorded per day. It doesn't just silence extremists when C-9 is introduced. It would silence ordinary people who will become afraid to speak their minds on any contentious issues for the fear that their words might actually be misinterpreted by an authority or maliciously reported by a neighbor. If you think I'm crazy, I want you to think back at 2020, 2021, during the COVID restrictions, when neighbors snitched on each other just to report what you were doing within the context of your home. And this will bring us to the most critical question. Who really bears the risk of these new powers? Laws with blurry boundaries don't affect everyone equally. It has an asymmetric effect. They're most likely to be used against those with unpopular opinions or against minority communities, whether religious or political, who lack the resources often to fight a lengthy court battle. They will create a system where the risk falls the heaviest on dissent, the nonconformist, and the person whose sincere beliefs suddenly fall in the wrong side of this new definition of hate that will be embedded in the criminal code. Now, this is made worse by the third part, which I mentioned earlier in Bill C-9, the move to remove the key safeguards. Because for many years, a prosecution for hate propaganda required the personal consent of a provincial attorney general, a high-level legal check designed to actually stop frivolous or politically motivated cases. Bill C-9 proposes to scrap that, handing the decision to local prosecutors. At the same time, there's been a controversial parliamentary committee to remove a long-standing defense for expression of good faith of religious beliefs. This is raising a lot of alarms among faith-based groups that quoting their own sacred text from the scripture could actually become a criminal act. And many people online have expressed concerns about this. I won't dwell too much on this. Each one of these changes on its own, if you look at it, it's a very small shift. But when you lump them together, they represent a systematic dismantling of the guardrails designed to protect free expression in a democratic society. Now, we're left with a paradox. A law that is designed to protect the vulnerable could end up creating a new kind of vulnerability for everyone. A bill that is sold as a tool for safety could actually become a weapon of silence. The central issue here isn't the desire to combat hatred. That's a goal that we can all share, no matter your political leaning or affiliations, we can share the goal that is important to combat hatred. But the issue here is the quiet and steady expansion of discretionary state powers. The danger lies in giving the government a brittle new weapon that is forged from legal definitions of an emotion and then handling that weapon to thousands of individual authorities to wield as they fit in the downstream and without the old safeguards put in place. This is not a partisan issue. I hope not. And I hope I have not communicated this as a partisan issue. I desire to actually put aside my political leanings or affiliations and talk about this as objectively as possible, because the power to define and punish speech, once granted to the state, won't care about your politics. If you think you're on the fine side of the law right now, I would implore you to actually think twice and think again. It's a power that can be turned against any group, any person, at any time. Whenever the political winds turn against you, I think this is a moment that demands not an outrage, not protest, but scrutiny. So here is the call to action in all of these, actually. Don't take my word for it. I want you to grab this bill. I will pin it in the description. It's just a 2-page document. I want you to grab this bill and read it for yourself and see what it actually says. Then when you're done, contact your member of parliament. It doesn't matter what party they belong to. Ask them the hard question. Don't ask them whether they be against hate or not, but ask them what safeguards, what guardrails are they putting in place to protect speech in Canada. Ask them who bears the risk when the definition of a word gives the state this level of power. Grab the link in the description that makes it easy, provided by the Canadian Federation. I'll pin the description there to actually reach out to the member of parliament in your own local community. And if you believe this conversation is very important, I wanted to share with a friend who does not know or doesn't care about this yet, because the consequences of this bill are something that no one seems to be ready for. And I think the time to get ready for it is now, before it's too late. Well, if you got any value from this conversation, I want you to click on the subscribe button to help support the work on the channel. I'll see you very soon. Take care. Bye-bye.